Just this week, there is the story of Maria Garcia Juarez, as told by Michigan Public Radio. As she tries to adjust to a country she's never known, Mexico, her American husband, Eric Orozco, remains in Detroit, suffering from leukemia and caring for their 2-year-old son, David. Juarez spent her entire life in the United States after her mother smuggled her across the border when she was 8 months old. Now 23, the former chiropractor's receptionist has never become a citizen, could not become a citizen, and was deported from Detroit in May because she stole 2 cars when she was 17. Juarez never qualified for the Deferred Action for Childhood Arrivals or DACA program because of the car thefts. Still, her story of separation, loss, fear, and estrangement is but one amidst a humanitarian crisis for unauthorized Americans, a crisis that the US Constitution's birthright provision, one that is often held out to be exceptionally robust, cannot reach or resolve. Reconstruction brought about a legal revolution that was unfinished at best. Ratification of the 13th, 14th, and 15th Amendments to the Constitution marked a sea change. Slavery was abolished. Equal protection to all citizens, regardless of race, color, or previous condition of servitude, was guaranteed. Voting became the subject of constitutional oversight. These provisions marked an upending of the pre-war legal regime. Reconstruction fundamentally reordered the nation's constitutional scheme by establishing a new and far-reaching federal supremacy and laying the foundation for the culture of rights that was to follow. Since their ratification, the Reconstruction amendments have proven to be both highly durable and hotly contested. Birthright citizenship is among the most far-reaching and the most disputed of Reconstruction's legal legacies. The 14th Amendment broke a silence present in the Constitution of 1787, providing, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state within they reside. With this, birthright citizenship assumed a central role in arbitrating national belonging. The principle of jus soli, the right of the soil, had a long history in English common law. Still, it penetrated widespread consciousness in the United States only after its constitutionalization in 1868. Many of us, many 21st century Americans, take for granted how birth liberally bestows upon them and their children citizenship, even as today most of the world limits the effect of jus soli principles. Birthright has always required careful interpretation and faced outright challenges. Recently, before the United States Supreme Court, was Tuwawa versus the United States. Born in American Samoa, Lele Tuwawa challenged his designation as a non-citizen national, arguing that he was a citizen of the United States by virtue of birthright. Historians of citizenship explain that despite their birth on United States soil, American Samoans have been denied the right to vote pursuant to racism rather than the Constitution. The Supreme Court agreed, at least to the degree that it allowed their second-class status to stand. Other debates take up the status of the children born to unauthorized residents. Birth ties these children to the United States. Still, some scholars of citizenship argue that such children may be deemed beyond the privilege of birthright. Legal historians have taken this debate from law reviews to the public square. Their competing analyses turn on readings of the 14th Amendment, making the scope and the application of birthright citizenship a hotly contested question even today. So it has been for nearly 200 years. Indeed, it's difficult to point to any moment during the past 2 centuries when the principle of birthright citizenship was not up for debate. The Reconstruction era ratification of the 14th Amendment, in this sense, is best understood as an important but not definitive moment in the history of birthright. The import and the limits of events in 1867 and 1868 followed on the heels of antebellum debates, pre-war debates over the status of free African Americans. And they were followed by continued uncertainty about birthright when, at the end of the 19th century, questions plagued the children of Chinese immigrants because their parents were ineligible for naturalization. The 14th Amendment largely resolved the citizenship dilemma faced by former slaves. It did less well for the US-born children of immigrants who in the 1890s and today face questions about where they are situated along the nation's borders of belonging. The first debates over birthright citizenship predate Reconstruction altogether. As early as the 1820s, lawmakers asked whether former slaves and their descendants were protected from arbitrary removal beyond the nation's geopolitical borders, and the answer turned on views about birthright citizenship. It was a constitutional puzzle generated by colonization schemes and so-called black laws that threatened to banish, exile, or otherwise remove free Black Americans from the United States. The underlying view was that the US never could really succeed as an interracial democracy. The questions were made only more complex because more close to the ground, federal officials conducted business in a contradictory fashion. The post office barred Black mail carriers at the start of the 19th century. It was said only citizens could carry the US mail. At the same time, customs officials issued seamen's protection certificates that proved the citizenship of free Black sailors in foreign ports. Were they citizens by birthright, free people of color might enjoy the privileges and immunities guaranteed by Article 4, Section 2 of the Constitution. Black activists and their allies built a claim grounded in jus soli. Birthright citizenship, it was argued, bestowed a right to place, a right to remain within the nation's political and geographic boundaries unmolested. Congress twice took up the puzzle of Black Americans and birthright in the 1820s. On both occasions, it fumbled. In 1821, a clause in the proposed Missouri state constitution mandated laws to, quote, prevent free Negroes and mulattoes from coming to and settling in the state under any pretext whatsoever. Congress asked, would a prohibition against the in-migration of free persons of color violate the Constitution by drawing an impermissible distinction between citizens of different states? The resulting debate stretched over many days with forceful advocates on both sides. Some said free Black people were citizens. For example, if a person was not a slave or a foreigner, but born in the United States and a free man going into Missouri, he has the same rights as if born in Missouri. That was one view. Others saw no conflict in the Missouri Constitution, the implication being that free Black Americans were not, constitutionally speaking, citizens. In the end, Missouri was admitted pursuant to a constitution that retained the troubling language. Still, Congress admonished the state not to enact any laws that would impair the rights of citizens, including free people of color. It was a fumble. 5 years later, in 1826, Congress returned to citizenship, reaching a similarly ambiguous resolution. A free Black New Yorker, Gilbert Horton, was detained in Washington, D.C., charged with being a fugitive slave. He was threatened with sale to cover his jail fees, and Horton was only later freed with help of Governor DeWitt Clinton of New York, who demanded Horton's release because Horton was a citizen, a free citizen of the state of New York. New York Congressmember Aaron Ward placed Horton's case before the House, asking the Committee on the District of Columbia to inquire into and consider the repeal of any law which authorized the imprisonment of any free man of color being a citizen of any of the United States, and his sale as an unclaimed slave for jail fees and other charges. What erupted on the floor of Congress was a radical difference of opinion, as the notes put it. Some lawmakers claimed as a matter of right that Black people held to be citizens of the United States in the state of New York should enjoy in every other state the same privilege. Others maintained we have the right to exclude free people of color, to eject them and to limit their privileges when we admit them to reside among us. The matter moved forward, but only by way of a murky compromise. Ward dropped his assertion that free men of color were citizens, and with that, the committee proceeded into its inquiry about the matter of jail fees. Attorneys General also confronted race and birthright. Shades of Congress's indecision surfaced there too. In 1821, Attorney General William Wirt was asked if free Black men could command American merchant vessels while federal law barred non-citizens from commanding such ships. His answer was a qualified no. If free Black Virginians, in this case, were not full citizens of their state, they could not be citizens of the United States. But Wirt's opinion left an opening. Were a Black person deemed a full citizen of his individual state, he might also be a citizen of the United States. 3 years later, in 1824, Wirt rendered an opinion on South Carolina's Negro Seamen's Act, which provided that Black mariners entering the state would be detained while their ship was at anchor. He deemed the statute unconstitutional, holding that only Congress had the authority to regulate such commerce. It wasn't exactly an affirmation of free Black citizenship per se, but it put Wirt on the right side of the question. Wirt's successor was Roger Taney, and Taney visited this question about Black ships' captains. When queried about the constitutionality, Taney took a view opposite to that of Wirt, asserting that free African Americans, quote, were not looked upon as citizens by the contracting parties who formed the Constitution. He continued, the articles of the Constitution which gives to citizens of each state the privileges and immunities of citizens was not intended to include the colored race. Taney's prose countered Wirt's view while leaving unresolved whether Black Americans could be citizens of the individual states. The possibility that state and federal citizenship might not align or be otherwise linked to the same one Congress had sidestepped, this was the problem of the Gilbert Horton case, of course. By the 1850s, courts were no less divided than had been Congress or the attorneys general. In Scott versus Sanford, now Chief Justice Roger Taney turned to free Black citizenship, concluding that the plaintiff, Dred Scott, and indeed no Black American, enslaved or free, could be a citizen of the United States in constitutional terms. Justices John McLean and Benjamin Curtis dissented. McLean's opinion recognized birthright citizenship, echoing the views expressed in Congress 30 years earlier. The first section of the second article of the Constitution uses the language, a natural-born citizen. It thus assumes that citizenship may be acquired by birth. Birth on the soil of a country both creates the duties and confers the rights of citizenship. McLean acted on his ideas. In July of 1857, just months after the issuance of the Dred Scott decision, he was sitting in the Federal Circuit Court in Illinois, and he limited the application of Dred Scott in a case called Mitchell v. Lamar. Joseph Mitchell was a free African-American man from Illinois who brought a suit against Charles Lamar of Wisconsin for damages in connection with an assault. Did a federal court have jurisdiction? McLean thought it did, and he reasoned that Mitchell, a free black man not descended from slaves, was a citizen. He wrote, "A freeman who has a permanent domicile in a state, being subject to its laws in acquiring and holding property, in the payment of taxes, and in the distribution of his estate among creditors or to his heirs on his decease. Such a man is a citizen, so as to enable him to sue, I think, in the federal courts." Here, it would be a mistake to understand Dred Scott as having settled the question of birthright citizenship. Justices sitting in lower federal courts would narrowly construe its application. Driven by the challenges presented by visible and growing communities of free African Americans, lawmakers confronted questions about the nature of citizenship. They were not of one mind, as we've heard. And the debate in Congress, the differences between attorney generals and Supreme Court justices evidence this murky state of affairs. What is clear, however, is that there was in the pre-Civil War era a well thought out and robust understanding of what was a muted but still very present endorsement of birthright citizenship in the Constitution. More familiar for most of us is the story of birthright citizenship thinking in the era of the Civil War and Reconstruction. Indeed, the period is often regarded as the starting place for birthright citizenship in law. For us, with the pre-war decades in clear view, we can begin to link ideas that had their origins in the 1820s to those of the Reconstruction era. What was new in the 1860s was the possibility for radical legal transformation, a transformation that accompanied war and its aftermath. In 1864, Attorney General Edward Bates had in mind the debates among antebellum lawmakers when he developed an opinion on free black birthright citizenship. Bates was asked whether black men might command American vessels when federal law limited such duties to citizens of the United States. I hope that's now a familiar question because we heard how both Wirt and Tawney had wrestled with that very question. Bates reached, however, a different conclusion. He rejected the view that citizens might be recognized only by the privileges they exercised. That is to say, military service, holding office, and voting were not signs of citizenship. The equation worked in the inverse for Bates. He acknowledged the Constitution's general silence, but viewed its recognition of the natural-born citizen as significant, seeing no basis for an intermediate legal category between citizen on the one hand and alien on the other. The general rule, he explained, was that, quote, "every person born in the country is, at the moment of birth, prima facie, a citizen." Might race or color work to rebut the presumption of citizenship? No, Bates concluded after revisiting the reasoning of attorney generals before him, including Wirt and Tawney. He wrote, "The free man of color, if born in the United States, is a citizen of the United States." After careful study, Bates arrived at a view that was familiar to the era's students and scholars of citizenship because the Attorney General echoed the Congress members' debates of a generation before. Bates presaged new thinking in Congress about birthright. Between 1866 and 68, through two quick, hard-won, and powerful agreements, Washington lawmakers took up the status of Black Americans with birthright as their centerpiece. They aimed at three formidable barriers: Dred Scott from the Supreme Court, the pre-war state Black laws now remade into post-war Black codes, and finally the silence in the Constitution when it came to the rights that attended citizenship. The resulting Civil Rights Act of 1866 overturned the pre-war regime. Up front was birthright. All persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, and such are citizens citizens of every race and color without regard to any previous condition of slavery or involuntary servitude. Swept away without comment was the long-standing threat of banishment or exile that Black laws and colonization schemes had posed. In its place was an enumerated set of civil rights that gave citizenship new content, including the right to make and enforce contracts, to sue, be parties and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to the full and equal benefit of all laws and proceedings for the security of person and property as is enjoyed by white citizens. With its ratification in 1868, the 14th Amendment became the touchstone for birthright citizenship, to which many of those aspiring to national belonging in the United States would turn. The application of the amendment's birthright provision was not without controversy. Even the fine points of birthright were subject to dispute, as was apparent when the first Black member of the Senate, Hiram Revels, arrived to take his seat in 1870. Had Revels been a citizen for the Constitution's requisite 9 years? Perhaps not, some argued, if his birthright was set in place only with the 14th Amendment's ratification in 1868. Revels was eventually seated, and the debate over his eligibility as a senator signals an important shift. None of his opponents doubted that Revels was a citizen. His birthright was undisputed. The only question was when that right had vested, and the ultimate answer was that the 14th Amendment made Black Americans citizens, remade them citizens back to the date of their birth on U.S. soil. Erased was any suggestion that Black men and women were still subject to arbitrary exclusion, banishment, or removal, as had been strongly suggested by some pre-Civil War lawmakers. Still, the 14th Amendment did not serve as an uncompromised weapon against inequality during the last decades of the 19th century. Forces lined up, including those consistent with white supremacy, to limit the amendment's meaning. What Congress did next helps us see how the constitutionalization of birthright still left unresolved critical facets of national belonging, even for Black men and women. A nagging vestige of the pre-Civil War legal regime was the Naturalization Act of 1790, still in effect. It limited eligibility for citizenship to free white persons. Future Black immigrants and longtime residents of the United States were not made citizens by the 14th Amendment. And so here, Congress comes back to re-examine the Naturalization Act, and Charles Sumner proposes striking the word white to remedy the problem. But the prospect meets with opposition from those who feared that such a change would open the door to the naturalizations not of Black immigrants. The striking of the word white might also make eligible for citizenship Chinese immigrants. The revision's final language extended naturalization laws to, quote, aliens of African nativity and to persons of African descent. No new provision regarding Chinese immigrants was included in the 1870 law, leaving only a very slim possibility that they might come in as white persons. By 1882, of course, we know that the first of the Chinese Exclusion Acts closed this door tight, making explicit that Chinese immigrants would remain aliens. What of the US-born children of Chinese immigrants, those natural-born descendants of permanent aliens? The 14th Amendment's birthright clause might appear to make plain their claim, but an interpretation emerged in the years after 1882, one that turned not on the amendment's jus soli principle. Instead, it relied upon the qualifying phrase, subject to the jurisdiction thereof. Those born in the United States were citizens, except when they were exempted from domestic law and regulation, a provision that initially had in mind the children of foreign diplomats. Anti-Chinese views led to a new and more robust interpretation. What was said to be an indelible loyalty to the Emperor of China held by such immigrants was passed on to their children. The children of Chinese immigrants were said to be permanent aliens, like their parents, because their inherited fidelity to China rendered them incapable of submitting to the jurisdiction of the United States. When the case of the United States versus Wong Kim Ark reached the Supreme Court in 1897, it reflected the degree to which thinking about the 14th Amendment and birthright remained contested long after Reconstruction. Not only were highly influential legal minds prepared to opine that children born on U.S. soil were not citizens by way of an inherited political disability, low-level administrators, including custom agents, held such views and were prepared to act upon them. Wong was a San Francisco native, and he had returned to the United States once from a visit to China unmolested in 1890. In 1895, he was detained upon arrival in the port of San Francisco. Custom collector John Wise and U.S. Attorney Henry Foote agreed that Wong should be rightly excluded as an alien. His birth on U.S. soil was overridden, in their view, by his indelible foreignness. Only rulings by the U.S. District Court and then the U.S. Supreme Court affirmed Wong's status as a birthright citizen. Was a child born in the United States of parents of Chinese descent who at the time of his birth are subjects of the Emperor of China, but have a permanent domicile and residence in the United States and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China. Is their child a citizen of the United States? And the court's answer was yes. That those like Wong would not be excluded from the nation's geopolitical boundaries resonated deeply with the claims set forth on behalf of free African Americans more than 8 decades earlier. Birthright citizenship was embodied in a claim to place, to remain, to come and to go and return. Birthright has a history that extends across nearly the whole of the 19th century. It entered legal debates during the antebellum era through the constitutional puzzle of free African Americans. In the era of the Civil War and Reconstruction, birthright took on new significance as questions about the incorporation of former slaves into the nation led to the constitutionalization of birthright. The principle and the constitutional history that gave it application were, however, not settled. The children of Chinese immigrants confronted the denial of their birthright in custom house confrontations, settled only when the Supreme Court carefully examined, for its first time in history, the record of birthrights past and its application to those who claim their place within the nation. Defining who is a citizen is a fundamental of democracy. Our founding Constitution was silent, requiring the U.S. to only later settle on ideas and concepts of belonging. No 2 instances more so than those of the 19th century's former slaves and the 21st century's unauthorized immigrants have tested our laws and our beliefs. 150 years ago, the U.S. was hard at work defining citizenship. Americans watched as lawmakers remade the Constitution into a more inclusive instrument of democracy. The 14th Amendment remedied the original Constitution's silence on the subject. No community had been more haunted, as we've heard, by the Constitution's absence of a citizenship clause than former slaves and their descendants. They had lived and labored for generations in a legal limbo that birthright citizenship promised to resolve. Former slaves and their descendants faced grave threats as non-citizens. In the decades before the Civil War, they numbered nearly 500,000, or 1.6 of the nation's population. Most had lived in the U.S. for generations, building families, schools, and churches. Their labor was the engine of prosperity, be it on rural farmlands or urban cityscapes. The answer for them came only through a revolution. 4 years of civil war and the near dissolution of the nation brought an end to slavery and the enactment of a new constitutional regime. The adoption of the 14th Amendment in 1868, as we've heard, guaranteed citizenship to those in the United States, including former slaves. Birthright ended threats of removal, even as questions about the full rights of Black citizens were yet to be answered. There's much to be admired in the work of Reconstruction-era lawmakers. They took steps toward a more complete democracy. But today, their definition of what makes an American falls short of resolving our current citizenship crisis. Communities that include unauthorized immigrants find too little recourse in the birthright principle. Despite building families and institutions across generations, they are, not unlike former slaves, placed outside the nation's borders of belonging. These two communities, former slaves and unauthorized immigrants, might appear far apart in time and circumstance. Certainly the cases are not identical. Free African Americans had origins in a system of captivity, of brutal compulsion, and of forced labor. Unauthorized migrants are here by way of economic and political coercion and work as nominally free laborers. Still, their experiences converge when it comes to citizenship. In both instances, the nation permits people to establish thriving communities without resolving their legal status. And two enduring aspirations link former slaves and unauthorized migrants across 150 years: the desire to remain within the nation's territory and to defend against arbitrary removal beyond its borders. For today's unauthorized immigrants, the 14th Amendment provides no relief. The once radical promise of birthright citizenship is beyond their reach. Their lives tell part of the story. The Pew Research Center estimated in 2014 11.1 million unauthorized immigrants, 3.5% of the overall population, reside in the United States. These men, women, children have built families, homes, businesses across generations. Their labors are an engine of prosperity, especially in agriculture, industry, and the service sector. Integral to the country in which they live, today's unauthorized immigrants nonetheless have no access to the rights of citizens. They have no unassailable claim to place. This year began with anti-immigrant threats of mass deportation. What followed has been more quotidian, but no less harrowing. Workplace raids discourage even documented immigrants from their jobs. Public gatherings are canceled because community celebrations invite surveillance and apprehension. With no path to citizenship, the 14th Amendment becomes a scythe that cuts across generations. Families of mixed status confront dislocation and separation as birthright slices through households, severing cross-generational ties. It is a haunted existence that produces lives subject to the arbitrary winds of politics and policy. Today, the nation faces a new challenge to our democratic ideals. How should we regard unauthorized immigrants? For these members of our community, the 14th Amendment does not promise inclusion. Instead, the shortcomings of our 19th century constitutional scheme are exposed as people said to be non-citizens face removal, or in 21st century terms, deportation. Without a remedy, we've begun to see friends, neighbors, co-workers, and family members become outlaws. The 14th Amendment's ratification is rightly appreciated as an important step toward a more perfect union. Few doubt today that Black Americans, indeed all Americans born in the United States, are citizens. Still, the decades of insecurity endured by former slaves makes plain how our nation has tragically blundered over citizenship in the past. For communities that include unauthorized immigrants, a new reign of terror is underway. as in 1867, people living in the U.S. today face schemes that aim to forcibly excise them from the nation. For former slaves, the 14th Amendment was an instrument of hope, as birthright citizenship extinguished threats of removal and opened doors to membership in the body politic. Nearly a century and a half later, its meaning and purpose have been transformed. Unauthorized immigrants confront the same 14th Amendment, passed to secure the rights of former slaves, while their experiences expose its tragic limits. Thank you very much.
I can keep it queued, but I know Professor Jones would be more than happy to take your questions and have a conversation.
First, can you explain the picture there, why the protest, what his issue is, and why he apparently thinks that expanding 14th Amendment protections for illegals would somehow work to the detriment of Black citizens, and why that would be in his view?
Sure. I think one way to explain this view is that it's about politics and not law, right? So it's a very instrumentalist moment there on the street with the placard. But there certainly is a strain of thought that goes back to 1866, goes back to 1868, and reads those moments as privileging somehow former slaves and Black Americans as contrasted with others who might make claims to citizenship. The argument that the essence, the core, the intent of the Civil Rights Act of 1866 and the 14th Amendment was as principally a remedy for former slaves and not one that should extend to other residents in the U.S. is one that gets made on placards like this, but also gets made in op-ed on the op-ed pages of the Washington Post and in places like the Yale Law Review.
It seems like often there are, I guess, reincarnations of these same issues with this problem. So what do you think are some future versions that we should be looking out for, some future, like, I guess, concerns we should be looking forward to with the 14th Amendment?
So I used to be someone who, when debates over the birthright provision of the amendment really became animated, I was someone who thought, I'm not sure you want to put that out for sustained debate, that because there are on the spectrum those who would repeal the 14th Amendment's birthright provision altogether, right? So one end of the spectrum is to repeal birthright and to put in its place most often what's advocated for is a kind of allegiance or oath-taking on the part of U.S. citizens in order to be a citizen of the United States. It's a radical rethinking, isn't it, of the way we think about citizenship today. And for a long time, I resisted it because of that radical thread. But today, I would say, if we don't come back to the shortcomings of this dimension of the Constitution, if we imagine that what the 14th Amendment did was settle the question of who could be a citizen of the United States, we risk, I think, certainly the judgment of history, right, that will look back at this moment and ask, as we, I think, rather blithely can do today, ask about how it was we didn't recognize the citizenship of Black Americans for so long. But I know you want to get in, so go ahead.
Okay, so what you just said about taking an oath and possibly that being a means to citizenship. It seems though in that instance, the oath is functioning as some kind of like a contract or like an agreement more so. How does that come into, how does that interact with like competency issues? Like kids, like people who can't necessarily understand the oath or don't really know what the oath means.
Right.
What are you thinking about?
So the proponents of this view would suggest, for example, at birth, If you were born to US citizens, you are ascribed a provisional citizenship status, but that at adulthood, you would then take an oath and affirm and adopt the rights and the obligations of citizens.
Like pending citizenship.
Kind of provisional citizenship, yeah. Sure.
All right, I'm gonna start a queue. 1, 2, 3, 4, 5.
Great.
So you draw, first of all, thank you for coming and speaking to us. So you draw a lot of parallels between former enslaved individuals and then documents in these days. A lot of those are couched around the idea that the 14th Amendment doesn't necessarily encompass individuals that are acting within the realms of what could be a citizen or is a citizen. How do you reconcile that first? How do you couch that experience in contemporary Black experience? How do you reconcile those two? And secondary, in particular, what do you think is maybe the role of a citizen, and how would you yourself define a citizen?
Sure. One of the reasons that I was drawn to telling this story about former slaves before the Civil War, before the 14th Amendment, was to highlight one of the rights that was at stake in this period that very quickly sort of disappears from view as questions about civil rights and political rights observe. But for free Black Americans before the Civil War, the most pressing concern, the right that they are most eager and anxious to secure, is that to remain in the territory. And that falls away very quickly with the 14th Amendment as we move on. So I would say for us sitting here today, that while Black citizenship is an important and contested and troubled terrain for us, there are very few people who would argue today that Black Americans, by virtue of their Blackness, are subject to the arbitrary removal from the United States without process. And that was the status of Black Americans before the 14th Amendment. So it seems modest, right, when we set it alongside civil and political rights, but it's fundamental, right? That fundamental right is what's at stake. So what was it? Tell me the second part of your question.
Simply like how would you define citizen? Do you define privileges, rights, or duties?
So here, the same folks really debate this question as they are making the argument that they are citizens, which they do in newspapers and in political conventions at the podium. And they are ambivalent in some sense. There are some who argue perhaps you don't want to be a citizen of the United States. Why would you not want to be a citizen of the United States? Precisely because they understand it to carry obligations, right, as well as privileges. And in particular, they are beginning to recognize the complexity of what it means to become a citizen of a nation that in their own time is deeply rooted in white supremacy. They are very attentive to and moved by the fact of Indian removal in the 1830s. And so they recognize that to become citizens or agents of the United States is to perhaps then to take on the obligations to support these kinds of projects. And that will become a permanent dimension, I think, of African American political culture, is this ambivalence about rights versus obligations, privileges versus obligations, the obligation to military service, the obligation to support imperial projects at the end of the 19th century, are all going to be moments where you'll see Black Americans continuing to debate and question what it means to be a citizen. Into the 20th century, W.B. Du Bois is probably, right, the best known example of this question, when Du Bois finally renounces his U.S. citizen and migrates to Africa. So it is a perennial question, I think, for us. Thanks. Hi.
Again, Professor, I guess tying into what Terrence was asking, can you elaborate more on alternatives to birthright citizenship and how considers status of people who live here and identify as American with kind of security concerns, and something that
Sure. So I'm going to confess I'm not a policy person, and so I won't sketch out too much for you. But DACA is an example, right, of a modest beginning to the question about how to frame and reframe citizenship, and what is the sort of the deep principle principles underneath DACA. Partly they are about longevity, right, and a relationship to the nation over time. So we might think about what it means for people to have resided here. Does it matter to us whether someone has resided in the United States for 15 weeks or 15 months or 15 years, right? DACA introduces time. DACA introduces notions of innocence. I'm ambivalent about this, but I'll put it out there, right? That DACA is rooted in the sense that there are some people, right, who are here unauthorized and yet not responsible, right, for their own circumstances. But I think what DACA has opened the door to certainly is the question of family, and how does family work in how we think about immigration, naturalization, and citizenship, right? And that, I would argue, family is a very modest framework, and it is a framework across the globe for how nations think about citizenship. And if we only began to and found a way to include family as a core principle, as a core door or gateway to citizenship, we would be in a very different circumstance than we are today. And it's something that birthright doesn't thoroughly account for.
So my question is more to do with the political environment, in the sense that even the elimination of end to slavery or recognition of rights, it followed in a certain time frame. It was a global movement. 1807, it starts picking pace. 1840
starts with the Haitian Revolution. Yeah.
And by 1900, you have Western Hemisphere, which has abolished slavery, but then you also have a very rich culture of human rights, which comes in there.
Yep.
So that was a different time. And if you look at the time right now, it is a very anti-citizenship and anti-right period. And it's not only in the US, even though, I mean, the political environment here, I'm sure people would want to discuss that. But globally, as you see, it's just not the time for this kind of right. So what do you think about where we are?
Well, I guess I'd say the first thing I'd offer is that I think it's probably not a wholly correct characterization of the mid-19th century to look back on it as a period of the advent or the ascension, certainly not the easy ascension of rights. In the United States, the abolition of slavery comes about by way of what is still the most bloody and costly conflict in our history. It does not come by the example of British abolition or even French abolition. And so I think I would caution in the characterization of that period, which is to say the opposition is committed and prepared to expend a great deal in order to continue slavery and to deny African American rights. And that we might tell the story of the post-Reconstruction era is the long retrenchment, the long backlash, right? The cutting back. So I'm not sure, at least in the United States, we could tell a story about a golden age of rights in which all was possible, because probably it's more a story about what was in fact impossible, that our experiment in interracial democracy in the 19th century lasts a decade and no longer. So perhaps today and yesterday are more comparable than we think. For me, what's most important or intriguing about your point is that today we do have a a robust and well-developed human rights frame that would reject this analysis for thinking about undocumented immigrants, would reject the frame of the nation as the one for addressing a humanitarian crisis, that would recast all of us, in a sense, as global citizens entitled to a sense of fundamental rights that, in fact, might still include the right to place, right? But not by way of citizenship and the US Constitution, but by way of international norms and precepts. And I'm not, that is not the work I do, but I take that as an important friendly amendment to what I do, which is to say that if indeed I thought the United States was more so a nation that would open itself up to the kinds of standards that are being set by international law on these questions today, that might be the way forward. But I suspect that's as dire a prospect as anything we've talked about today. But thanks so much for the question.
If it's okay with you, I know I've already called on 2 more people. Maybe we'll take 2 more quick questions and then
Sure.
wrap up.
Yeah.
And in the case of deprivation of citizenship, for example, when the person is using the terrorism crime, a state can deprive and secure citizenship, is it a violation of human rights?
So you'll tell me about the human rights question. What I'll say, I think the historical record teaches us is that what we risk when we hold people beyond the possibility of citizenship, when we exclude them from the body politic, and what worried 19th century Americans, particularly as the communities of free Black Americans grew, as they expanded in literal numbers, was the sense that what was growing up were communities of outlaws, people who would not enjoy the privileges of citizenship and might not feel themselves bound by the rule of law in much regard at all. And so this is a dangerous moment. And Dred Scott goes one way on this question. Chief Justice Taney thinks that free Black Americans can be both controlled even as they are outside the bounds of citizenship. But in the state of Maryland, for example, when that state's high court has the opportunity to, in essence, import the logic of Dred Scott into its thinking about race and rights, that state high court says, no way. There were 75,000 free African Americans in the state of Maryland in 1858. And if we tell them they cannot come in the into the courthouse to pose their grievances, if we tell them that they cannot rely on law to protect their persons and their property, we are inviting in our midst 75,000 outlaws who will find other ways to resolve their disputes, certainly. But in fact, if we understand law in that view to be a mechanism, not of political inclusion or empowerment, but as a mechanism of social order and social control, it was very important for many Southern state courts to carve out fundamental rights for free Black Americans in this period as a way of knitting them into the social and political and legal fabric, that it's a very dangerous proposition to mark people as permanently outside of the body politic. Thanks.
So, Professor, what it sounds like to me is that once we deal with or try to grapple with the issue that's confronting one racial group, we have another group with discrimination, right? And I guess my question would be more so trying to be more optimistic about the future and young scholars like ourselves. Is this like intentional, like where we kind of have the 14th Amendment seems to be a win for Blacks, but is it a disservice for people of color to kind of take this as a win? And if so, how can we kind of empathize or more so sympathize with other racial groups and kind of address those issues? Because I kind of find in my writing, I kind of don't even confront those issues. I don't even speak on them. I kind of just focus on Blacks. And I'm just kind of wondering if people push back against it, and how can I better kind of address those issues? And how do we come together and kind of deal with it? You know?
That's a great question for me, an important one, because one of the questions I ask my students, I ask myself, is the degree to which we think the Black American example is the case that can stand in for the whole. Is it the quintessential case? Is it the exemplar? Is it the template? Is it the blueprint? And part of this piece, in fact, emerges from my teaching and teaching cases like Wong Kim Ark alongside the Reconstruction era amendments, and developing two appreciations, right? One is that, in fact, the Black American case does not stand in for the whole, right? That this argument that's made in Wong Kim Ark that Chinese Americans are indelibly foreign is not an argument that is ever made with respect to Black Americans. There were other arguments made against Black citizenship, but that foreignness, Chineseness becomes a distinct thread that is deserving, right, of its own appreciation for the role it plays. When? Well, I'd say today, right? The problem of foreignness. So if we think about the degree to which we understand anti-immigrant politics and policy is driven by race and otherness, well, it's partly by virtue of race, we would say, but we'd also have to appreciate, right, how it turns on ideas about others who are outsiders, who are foreigners, right, who cannot become fully and naturalized Americans in a fabric sense. So, so for me, the Black American case, I think, just doesn't go far enough to explain where we are today. And if that's part of what history can do, then I think we just necessarily have to be more capacious in how we think about the question of race and law. So, thanks very much.
Please join me in thanking.